I'm Chuck Douglas from Bow. I appear here in an individual capacity. I oppose the bill, and I would like to focus attention on the bill. New Hampshire is not going to change the nation's view on capital punishment. What happens in other states is interesting, but you have a specific bill in front of you that, with all due respect to John Broderick, I disagree with his analysis. First of all, the first sentence says, the provisions of RSA 630:1 are suspended. That means there will be no capital punishment charges brought, because you can't charge someone under a suspended statute. Doesn't make any sense. Would violate Senate Bill 463 if it were enacted. It also goes on to suspend the procedures and the place of execution provisions. But there will be no more capital punishment charges brought in this state if this passes. Second, the end of the first sentence says, it's suspended until methods exist to ensure that the death penalty cannot be imposed on an innocent person. Who will determine when the time has come? How will they do it? Who will determine what methods exist to ensure that the death penalty is perfect? Is it a court? Is it the House Judiciary Committee? Is it the Senate Judiciary Committee? The bill doesn't say. All we know is the death penalty is suspended, capital crimes are suspended until methods, whatever those methods are, exist to ensure it won't be imposed on an innocent person. What guidelines are they going to use, and what methods are they going to find? And I would submit to you that the second sentence is also worth looking at very closely in this two-sentence bill. The second sentence says the section will not apply to any person convicted of capital murder prior to the effective date of this section. That, what the folks supporting the bill have not told you, is that effectively no state or nation has ever executed someone after a prospective repeal of the death penalty. It's never happened. And I'll provide you copies of excerpts from an opinion last year by the Connecticut Supreme Court in the case of State versus Santiago, where the Connecticut legislature said anyone on death row stays there, but from this point forward there won't be any more executions. And the Connecticut Supreme Court said, we join all the other courts and nations that say once you do that, everyone on death row is out of death row. That is an impact that that second sentence has. That means Michael Addison walks back into a different cell from the cell he's in today. He's not back on the street, but he's out of death row at the state prison. That's exactly what every court has said, and that is the implication of what you're doing. So all I suggest to you is who, when, where, how, all of those questions are unanswered. And be aware that the odds are overwhelming that Addison is not going to be continued on subject to the death penalty, because I'm sure our Supreme Court, and I served there for 8.5 years, will join all the other courts in their analysis and say it's over. And I'll be happy to leave copies of excerpts. The Santiago opinion is quite lengthy. It's almost 90 pages, and what I've done is to take just the relevant excerpts and highlight them for you to aid you in your analysis. And I'll be glad to answer any questions. If there are any, I'll be glad to help.
Thank you very much,
All right.
Mr. Douglas. Are there any questions from the committee? Seeing none, thank you. The chair will call Richard O'Leary.